there are certain basic tools of doctrinal research. Statutory materials, subordinate legal materials, and case laws constitute the primary sources, while the secondary sources the researcher refers to are the textbooks, legal articles, parliamentary debates, etc. For example, if someone has to undertake a study on the principles of compulsory licensing under the law of patents, then the relevant provisions of the Patent Acts 1970, international instruments pertaining to compulsory licensing, law on compulsory licensing in different jurisdictions, findings of the court, and intellectual property appellate board, like in the matter of application for compulsory license by NATCO Corporation in Company Law Advisor 1, constitutes primary sources. While the commentaries on the provision pertain to compulsory license in standard textbooks, commentaries, articles in law journals, news reports, blogs, etc. would constitute secondary sources. So what are the advantages of doctrinal method? Doctrinal method provides quick answers to the practical problem at hand by analyzing the legal principles, concepts, and doctrines, thereby serving as a ready reference to people who didn't have a time at their disposal to understand that research by themselves. Because, comparatively speaking, a doctrinal research requires less time. So thereby it ensures a constant stream of information on a regular basis. Doctrinal method gives insights into the evolution and development of the law. For example, consumer protection law. It offers a logical explanation to the law and at the same time also highlights inconsistencies and uncertainties in the law. It reveals gaps, ambiguities, and inconsistencies in the law, thus informs us as to how law can be more purposive and effective. It lays down a roadmap to develop the law by avoiding the pitfalls. It helps in increasing the legal knowledge base. Future direction of the law can be predicted on the basis of such studies. It provides a sound basis of non-doctrinal research, because in deficit of the required preliminary knowledge, the venture of non-doctrinal research would be directionless and therefore futile. But there are certain limitations of doctrinal method. The first limitation is that it can be subjective and suffer from the vice of perception of the researcher about the required subject matter. Therefore, another person can reach upon an entirely different dimension to the same question. Further, it is devoid of any support from social facts. Therefore, his projection might be far off the social reality. This is a serious concern, as law can act as an instrument of social transformation. It neglects the factors that lie outside the strict brackets of law, which might have a bearing upon the legal principle, theory, or doctrine. For example, the recent amendment in the criminal law regarding rape, wherein a huge public outcry was an extra legal factor that shaped the law. The actual practice and attitudes of people who are the functionaries and those who implement the law is also not taken into account. For example, the attitude of judges, lawyers, police, administrative authorities, courts, and tribunals, etc. The qualitative research has following merits. It highlights the gaps between goals and social reality. It depicts a true picture of law in action. It highlights the gaps in relation to practice of law, enforcement agencies, and as well as in the use and underuse of the law by the beneficiaries of the law. It highlights the reasons behind failure of a law in real world. It may be inactiveness or lack of willingness on the part of those entrusted with the task of enforcing the law, or may be resistance on the part of intended beneficiaries for multifarious reasons like unawareness, fear of further victimization, huge costs in the terms of time and money. It thus exposes the weakness in the operation of law. In the modern welfare state, law acts as a tool of social and economic transformation. The qualitative research can bring forward the role and contribution of law in bringing about desired changes. It also can highlight the gaps that have been left in the law and social reality so that law can be reassessed in the light of new information. It serves as a significant resource in the form of a social feedback to policy framers, legislators, and judiciary so that they can better enforce, legislate, and interpret the law. It shapes social legislations in tune with the social engineering doctrine of the modern state. But there are certain limitations of qualitative research also. Qualitative research is extremely time consuming and also very costly. The researcher in this research has to build upon the bedrock of doctrinal research. He must be through with the doctrines and concepts, otherwise his research endeavor would be futile. The primary tools of data collection, namely interviews, questionnaires, and observation, requires a specialized skill set right from the stage of planning to the execution. Now, let us recapitulate what we have learned so far. From the above analysis, it can be understood that qualitative research arose primarily as a critique of doctrinal research. It was felt that the research outcomes were inadequate and incomplete in absence of an analysis done in real-world settings. Nevertheless, both research methods had their own merits and shortcomings, but it can safely be concluded that both informs the law and policy and are interdependent on each other. Thank you.